Hi, everyone. Thanks for joining me today. All right. Really important information that I want to share with you. You see, I've been reading the paper the last few days and reading the internet, and I just felt compelled to jump on here and talk to you. The information that I'm going to give in, it is good for everybody. Anybody who is facing any kind of civil litigation, this is useful information for you too. But right now, I want to talk to all of you homeowners out there that are finding yourself in some kind of financial situation and facing foreclosure. Okay. Because I said they're on the rise again. And the last time this happened, if you've heard me speak before, the last time this happened in 2008, only 10% of the foreclosures were ever challenged in court. That means 90% of the foreclosures just went through. There was no challenge, no nothing. They just went through. I don't want to see that happen again. So I want to do everything I possibly can. I want to give you as much information as I possibly can to avoid that from happening again, to keep you where you are in your home. Okay? So that's what this is for. All right. So how does this all begin? A foreclosure action, or any action for that matter. A foreclosure action starts with the filing of a summons and a complaint. So, what is this? What's a summons? Well, a summons is exactly what it sounds like. You're being summoned to court. All right. Uh, uh, the court is saying you have to go to court because somebody is saying something against you, and you have to show up and address it. So all it is. It's just, hey, come on to court. All right. So what's the complaint? The complaint is why they're bringing you to court. It is exactly as it sounds, a complaint. They are complaining about certain things. In a foreclosure action, each sentence, again, all complaints, each sentence in that complaint makes a factual statement, one fact that they're claiming. Okay. They, in a foreclosure, it would be that the homeowner signed a note. That would be one sentence. The homeowner signed a mortgage. That's another sentence. The plaintiff is the owner of that note and mortgage. That's another sentence. The homeowner failed to make payments on this date. It's another statement. Each one is a fact. Now, what you have to do is you have to file what's called an answer. You are answering, responding to every fact that they're stating in order to create what is called an issue of fact. It's a question of fact. Is that fact correct or incorrect? All right. This cabinet. If I said to you that cabinet is yellow, okay, and then you said to me, no, that cabinet is white. The two statements actually create what's called an issue of fact. What color is the cabinet? And that's the question that the court is going to address. See how that works? That's all it is. They're filing the complaint, which is their statements that they're saying are true. And you are filing an answer that says, no, statements are true, or their statements are not true. And that's why the court has to be involved. But if you don't file an answer, you don't serve your own answer, you don't show up, court has no choice but to accept everything they say is true. And it's just going to go straight through. Think of it this way. If you got a baseball game and two teams are supposed to play, one shows up and one doesn't. Who wins? Obviously, the one that showed up because they're the only ones there. The other team loses by default. They defaulted. They failed to show up. Same thing here. If you do not file an answer, then you failed to show up. And they're going to win. They're just going to go straight through and win. And that you should not do that. Now, you might be asking yourself why, because I've heard that question many times. I've been doing this for so long. A lot of clients, they say to me, but, I didn't make my payments in this and that. But the idea is, it's not so much that you're looking to win a house or win the case. What you're trying to do is you're trying to settle it. You're trying to get yourself in a position where you're back on track. Maybe something happened. Maybe there was a health crisis, or maybe there was a loss of a job. And now that situation has rectified, or it's going to be rectified. And you just need a little alteration, maybe a modification or a forbearance, to get yourself back on track. And the bank has not been working with you. Well, they don't have to, and they have no incentive. You need to create that incentive so that they will work with you. What's that incentive? It's called leverage. Now, in all cases, but I'm talking specifically for foreclosures right now, there are rules that have to be followed by everybody. Those rules come from the mortgage, the contract. They come from the law, the state, okay? And they come from the courts, which are procedures. There's many rules that exist that have to be followed by everybody. If a bank does not follow all the rules, especially the really important ones, because there are out there, if they don't follow the important rules, they could lose. And if they lose it all. So if you point out that they have made a mistake, they haven't followed the rules, that's your leverage. That's your leverage to get them to start working with you so that you can settle it. You can get back on track. That's why you file an answer, because you want that opportunity to fix whatever that's going on, and you want to get the bank to work with you to do that. And you want to give them a reason to have to do that. And what's that reason? Hey, you ain't going straight forward and getting a default judgment and just taking this case straight on. I'm not letting you do that. All right? Now, a couple other things I've heard from clients. And again, like I said, the moral aspect. Well, I didn't pay it. Yeah, I understand, but still go through. Another thing is you don't have a lot of time to file your answer. It's usually 20 days is the majority. There might be a reason for 30 days, but it's usually 20 days. Okay? You don't have to run out and get an attorney, because I know the attorneys are expensive. You do not have to run out right away and get an attorney. And that's usually a preventative. People say, I can't afford an attorney right now. I can't afford to pay my mortgage. How am I going to afford thousands and thousands of dollars to an attorney? Well, guess what? When it comes to an answer, you don't need an attorney right away. You can actually go down to the county clerk where the courts are. They usually have pre-printed forms. They're called pro se answers. They're pre-printed, and you just check off the boxes and you fill in the pertinent information and you file it. That's it. You don't need an attorney for that. Or you can go online. These forms can be found online. Or even not even a pre-printed form. If you understand what information you have to put in, you can write it on a piece of paper and send it to the court and send it to the other side. That's it. That's all that's needed to file an answer. Okay? That can take you all of about a day if necessary. So don't let the opportunity slip by. You're doing it to preserve your chances, your options. And if you've listened to me before, you know my whole philosophy is create as many options as you possibly can so that you have choices and you can figure out which one is going to work for you. And if that one doesn't work, I still have this option. If that doesn't work, I still have this option. Filing your answer keeps your options open. Okay? Another one, I want to address this too. I've heard I wasn't served. This idea of service has been confused. The first thing I'm going to say, and this is because I actually was asked by a client recently, is, well, what exactly is service? What's being served? All right. I know it's very simplistic, but yet it is kind of a legal jargon. Service, think of it like when you get served dinner. Okay. You're served dinner, they're giving you dinner. That's what service is here. They're serving you the papers. They're serving you the summons and complaint. That's what they're doing. That's what service is. Now, I've heard, well, I wasn't personally served. You see it on TV. Somebody comes, process server comes, gives it to you personally, and great, you've been served. It doesn't always work that way, and it doesn't have to. Now, the laws across the states, they can vary slightly, but for the most part, they are very similar. Number one is personal service. Okay. That's the actual giving. Then you have what's called substitute service, which means let's say you're at the grocery store, but while you're home, your significant other, or your kids are home. They can accept service for you. Now, there are rules that say who can or whatever, but yeah, somebody can accept service for you, or even at your job. They can serve somebody you work with at your job, um, and then follow it up with a mailing. Another one is what we call here is a nail and mail. What is that? That means they haven't been able to get you or get somebody you work with or somebody at the house. So what they do is they actually, it's not nailed anymore, but we say nail. They have to actually tape it or somehow affix it to your door. They nail it to your door and then they follow it up by mailing you another copy. It's called a nail and mail. All right. Publication. If they can't leave it at your door and they can't find somebody to serve it to and they can't find you, they can actually go to court and ask to publish the summons and complaint to somehow make you aware. Publish it in a community where you may be. All right. Another one just came across my desk actually 2 days ago. Was interesting. The plaintiff went to court and they said, we've tried everything. We can't do the nail and mail because it's a gated community and we can't get them. They don't have a job and all this other stuff. But we have been in communication via email with the borrower. Can we email them and then follow it up with a mailing? You know what? The court said, yeah. As long as it was a means that was likely to result in you receiving that summons and complaint, you're served. Does not have to be handed to you in person. So please, if you get home and the babysitter or your kids say, guess what, this came in the mail, don't get the idea in your head, well, they didn't hand it to me. No, this is good. Talk to somebody before you jump to a legal conclusion that might make you lose one of your options. All right. So that's service. All right. I was talking about creating options. The options are created again from the leverage, and the leverage is by showing that rules have not been followed. The way you can show that they didn't follow the rules is talking with somebody and having somebody on your side that knows the rules. This is where an attorney would come into play. All right. Again, it doesn't have to be right off the bat. Okay. But getting an attorney is a good idea because they know the rules, they know what has to be done. And yes, it does cost money. Because attorneys, it's their knowledge and their time that you're buying is basically the way I usually describe it. But not all attorneys make it impossible. Okay. First of all, you can start out with, I know in many, many states, they actually have uh, um, public public defenders or legal aid that will help you in the initial stages. They might even actually help you do an answer, or they'll help you with modifications through the beginning of the case, seeing if there's going to be a settlement. All right. Or there's housing counseling agencies. We have them here in New York, and I know many other states have them as well. They're not for profits, and they don't cost anything to the homeowner. So you can have somebody there by your side at the very beginning and it doesn't cost you any money. This is a good thing. This is why they're there, is to give you that fighting chance to preserve your rights. All right. But the bad side is that these individuals, these housing counseling agencies and legal aid, they usually don't go any further than the initial conferences, the initial trying to settle the matter. If it's going to go beyond settlement and go to trial or motions or anything, they're usually not going to stay on. That's not what they're there for. That is where you're going to have to get an attorney. But it doesn't mean that it's impossible. I'm going to tell you right now. For me, my fee structure is specifically set up so that homeowners can afford an attorney. All right. And it doesn't necessarily, I'm going to stop you guys right there, whoever's thinking of that. Just because it's affordable doesn't mean it's not that good. Okay. Most expensive doesn't mean always that it's the best. I love a good fight. I will fight and fight and fight. I love it. I've had the joy of actually going over to the Court of Appeals. I love it. All right. So I keep going. But I also know that there's a lot of people out there that can't afford a high price $700 an hour attorney. Remember, if you've heard from me before, you know I've been in your shoes. I know what it's like to be in foreclosure. All right. So what I do is I have a fee structure that it makes it affordable and possible for people to have an attorney represents them. And you know what? Wasn't my structure. I'm not the one that came up with it. I got it from other attorneys. So there are other attorneys that have these fee structures out there so that you, the homeowner, can afford. And I'm sure New York is not the only place that has attorneys doing these fee structures that help homeowners get an attorney. Okay? So that whole idea that I can't afford an attorney, please get that out of your mind. You get it out of your mind right now. All right. But when you go looking for an attorney, make sure you're getting somebody who knows what is going on. All right. That's why I'm here. I'm here to give you as much information as possible, making it understandable what goes on in the legal world, everywhere in the legal world. Today, I'm talking about foreclosures. But that's why I do it. I do it so that you, as the homeowner or as whatever, the plaintiff, the person facing a criminal charge or anything, you have a general idea of what is going on. So when you do go to an attorney, you know that there are rules. You know basically what documents are. You know what has to be filed. You know when things have to be filed. With this information, when you hire an attorney, if they don't know this stuff, go somewhere else. Because just because an attorney is affordable, doesn't mean they're valuable. All right. I know that sounds weird. What was I just saying? I was saying just because they're not expensive doesn't mean they're no good. But yet I'm saying just because they're affordable doesn't mean they're valuable. This is where you put your own thinking cap on. Because remember, you're going in for a fight. All right. This is your fight. So make sure you're ready and make sure that you have proper knowledge and the proper people on your team to make that fight. Okay. Now, I also want to just touch on if you miss the time period to get that answer in, you can still do it. All right. You can actually go into the courts. Remember, I said that you can also amend your answer later? All right. You could also still go into the courts and ask them if you can have a late entry, so to speak. That's the best way I can explain it. What you're basically doing is you're saying, Judge, I understand I didn't get here on time. I was running late. Maybe the bus was late, whatever. Just joking. But what you're doing is you're trying to tell the judge that you need the opportunity to jump in and defends this, that you're just a little late. And usually the courts, as long as you're not talking about years later, the courts are usually pretty good. They would rather decide the case on the merits than rather have somebody win just because of default. It's like wanting to watch that good baseball game. Just because the other team showed up late doesn't mean they're not going to let the game go through because we all want to see a game. All right. I know, bad analogy, but I'm throwing it in there. Anyway, reason, like I said, I'm here is when I see things like this starting to happen again, I want to do everything I possibly can to not have history repeat itself. I want that 10%, I want that up. I want that up to 50, 60%. And I want people to stay in their homes. We just got out of a really ugly 2 years. So we deserve some good stuff to happen our way. All right. That's why I say all I can. All right. Listen to me, your mother-in-law. All right. So again, I really hope this helps you. This is all applicable to any kind of civil action that you're facing. The summons and complaint and the answer, making sure you're timely answering, getting the right people on your team. This is applicable to everybody. But I'm talking to you right now, all of you out there, homeowners. Don't just roll over. Don't walk over. Don't walk away. Don't put documents on the side. Address it and address it and address it. Okay? And that's the only way that you're going to be able to come out of it on the other side. Trust me, I'm sitting here in my home. So I kind of know what I'm talking about. All right? Again, this is just some opinion and information and advice from me, your mother in law, and I'm wishing you all the best of luck. Thanks a lot.